Yes.
But on the second para, બાદ સપ્ટેમ્બર 2022 માં સિદ્ધાર્થ રાવળ અને તેમની પત્ની પાયલ રાવળ બંને અમારા ઘરે આવેલા અને તે વખતે અમોને જણાવેલ કે મારી કંપનીમાં સારું એવું વળતર મળી રહેશે, જેથી મેં સિદ્ધાર્થ રાવળ અને પાયલ રાવળનો અગાઉ મેં કરેલ રોકાણ ઉપર નક્કી થયા મુજબ વળતર ચૂકવતા હોય. સો એટ ધેટ પોઈન્ટ ઓફ there is no dishonest intention from the inception. રોકાણ તો અમને સારું એવું વળતર મળી રહેશે, જેથી મેં સિદ્ધાર્થ રાવળ અને પાયલ રાવળનાઓને અગાઉ કરેલ રોકાણ ઉપર નક્કી થયા મુજબ વળતર ચૂકવવા હોય લેખિતમાં પણ બાંયધરી આપી, જેઓની વાત પર વિશ્વાસ આવતા 10 લાખ તેમની કંપનીમાં રોકાણ કરવાનું નક્કી. આ બાબતે મારા શાળા દીપક રમણભાઈ રાવળ સોએનસો વાતચીત કરતા તેઓએ પણ કંપનીમાં નાણાં રોકવા તૈયાર દર્શાવેલી અને મારા શાળા દીપક શાહના પણ 20 લાખ રોકડા મારા ઘરેથી સિદ્ધાર્થ અને તેમની પત્નીઓને આપે. 10 લાખ. So all this 30 lakhs transaction is in cash. There is no material. 10 લાખ મારા પત્નીના HDFC ના સંયુક્ત ખાતા નંબર સોએનસો માંથી 15/9/2022 ના રોજ RTGS મારફતે સિલિકોન વેલ્થ મેનેજમેન્ટ કંપનીના ICICI ખાતા નંબર સોએનસોમાં RTGS મારફતે ટ્રાન્સફર કરેલા, પરંતુ RTGS માં ટેકનિકલ એરર આપતી નાણાં પરત અમારા ખાતામાં. So the amount was already returned back to them. Thereafter સિદ્ધાર્થ રાવળના ખાતામાં ઓનલાઈન ચૂકવેલા. Lordship, as per my instructions, that amount was also returned back to the Harshils in Kotak Mahindra Bank. અને આપીશું તેઓને તેમની વાત પર વિશ્વાસ આવેલો. થોડા દિવસ સુધી અમોને રાહ જોયેલા, પરંતુ અમોને કોઈ એગ્રીમેન્ટ આપેલ નહીં. જ્યારે પણ અમો એગ્રીમેન્ટની વિશે વાત કરતા તે કોઈને કોઈ બાણ. Thereafter, after a delay of 3 years, this FIR came to be filed. This Silicon Wealth Management Company is owned and operated by the father of the present applicant, Your Lordship. Kindly turn to the page number 23, the GST certificate, which shows that he is not the proprietor of the company. Page number 23, Your Lordship.
But then why did you accept money in personal account?
That was basically the amount was supposed to go into the investment account, and that due to some technical error, as per the allegation, due to some technical error, it was.
But then why did you, if you were really,
they transferred into the personal account, but it was returned back to the Harshil as per my instruction in Kotak Mahindra Bank, Your Lordship. And he is not the proprietor, he is not involved into it.
But then why did you accept 10 lakh?
That I did not accept it based on that they transferred into my personal account, Your Lordship. On the instruction of the father. On the instruction of the father, they transferred into my account, and that was also returned to the Harshil's Kotak Mahindra Bank account, Your Lordship. And this is purely related to civil dispute, Your Lordship. Lordship may turn to the page number, because there are, and on the law points, Your Lordship, this they have not followed, because the maximum punishment is up to 7 years. They have not followed the Arnesh Kumar, they have not followed the Satyendra Kumar until they have not issued even 35(3) notice, Your Lordship. And on the contrary, Your Lordship, the present applicant was arrested on 5th March 2026 from his residence from Pacifica Enclave around 6:30 in the evening. He was taken to the, without any due process of law, he was taken to the crime branch. He was made seated there. He was assaulted. Thereafter, he was handed over to the satellite police station on 6th March, where the entire day he was kept. Thereafter, he was shown as an arrest on 6th March 2026 in the evening, and he was produced before this court on 7th March, Your Lordship. Thereafter, and there is a judgment. Lordship may kindly peruse the judgment. Page number 4. Para 8, I may be permitted to read, Your Lordship. Am I with my Lord? Page number 4, para 8.
Yes.
Once a court, while dealing with the bail applications, finds that the fundamental rights of the accused under Article 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on the bail. The reason is that the arrest in such cases stands vitiated. It is the duty of the every court to uphold the fundamental rights guaranteed under Article 21 and 22. So here in this case, Your Lordship, the Article 22 subclause 2 has been violated and Section 58 of BNSS has already been violated. And he was not informed the ground of arrest in the writing. Their relatives were not informed because there is a judgment of Vihan Kumar. Please. Wherein the Honorable Apex Court says that, please. That it is mandatory to inform the relatives as well in the communication. My Lord has access to Vihan Kumar judgment.
But first, let me go through your first judgment.
Please, Lord, please.
Now, when were you arrested?
The physical custody was taken on 5th March from the Pacifica enclave Vaishno Devi. Thereafter, he was taken to the crime branch. Thereafter, he was handed over to the satellite police station on 6th March. And in the evening, he was shown arrest. And he was produced before this court on 7th March.
Now, what are the facts of the judgment in which you are relying?
The facts of the judgment is that he was arrested from the airport and he was produced after 24 hours.
LOC was issued against him.
NOC was issued.
So how this judgment would help to you?
But in the judgment, it clearly says that when there is a violation of Article 22 subclause 2.
That principle is there. Now, on what basis the court has arrived at a conclusion? Yes, there is a breach. That would be on factual basis. On the principle is there. Okay, once that mandatory provision is not complied, then he may be released. That is the principle.
I'm relying upon the judgment to
But when you point out how your case on factual metrics, it is similar to this case. That is what I know.
Here also, Your Lordship, kindly see, he was arrested, responded at IGI airport from 4th March 2022 on behalf of the appellant. The finding of the fact recorded in the paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 11 hours.
Okay. So who took the physical custody?
The crime branch.
No. In this judgment.
Here the enforcement department.
So appellant is the enforcement department. So he took your custody on 5th March. Now whether your custody was taken by this very same police station.
It was taken by the crime branch.
So now you will have to point out when the custody from crime branch was taken by this agency.
It was in the morning.
Morning which date?
On the 6th March.
6th March.
6th March. And he was shown arrest on the evening, in the evening. If arrest memo can be shown by the in the evening. And then after he was produced on 7th March before this honorable court. That's it. And there is another judgment which says Vihan Kumar judgment, if my lords may see. I would directly take my lords to the operating portion of the judgment. The last 2 pages, which says para 3, last 2 pages. Page number 2. Am I with my lord?
Page number?
Page number 2 of the last 2 pages. The operating portion of the judgment. Last 2 pages of the judgment. And para 3. Para 3. Para 3.
3.
Paragraph 3 of last.
Lordship,
Court is for
last two pages. There is a second lordship operating.
here.
Para 3, your lordship. The purpose of inserting 50A of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friends, relatives, or persons nominated by the arrested person. It is to ensure that they would able to make immediate and prompt actions to secure the release of the arrested person as permissible under the law. The arrested person, because of his detention, may not have immediate and easy access to the legal process of securing his release, which would otherwise be available to friends, relatives, and such nominated person by way of engaging lawyers, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating to the grounds of arrest to the detainee and in addition to his relatives, as mentioned above, is not merely a formality, but to enable the detained person to know the reason for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, or nominated person to secure his release at earliest possible opportunity of actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other person as may be disclosed or nominated by the arrested person, so as to make mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal, Your Lordship. Here, none of the family members have been informed.
You are informed. You are informed.
I was just made to sign I was not explained the grounds of arrest. I was just made the sign, and none of the family members have been informed the grounds of arrest, Your Lordship. And this is purely a civil dispute wherein in the one of the cases with the DCB police station, the Honorable High Court has already granted stay, keeping the Sailesh Kumar judgment. That order is on the page number 32. Page number 32 of the petition. And
Page number.
Page number 32 is the order of Honorable Gujarat High Court, wherein the FIR is stay, keeping the judgment of Sailesh Kumar. Page number 32 in DCB police station's FIR. And I may take my lords to the judgment of Sailesh Kumar, the operating.
Yes, what is that?
Page
You have
32.
that? You have that judgment?
Yes, I will produce it. Page number 29 can be seen. Page number 29 of the petition. 29 of the petition, I have already placed on record. Page number 29.
Page number 29.
I may, yes, there is a para 9, which is relevant. I take my lord's name. Para 9. We have been able to understand it is there is an oral agreement between the parties. The respondent number 4 might have parted with some money in accordance with the oral agreement, and it may be that the appellant herein owes a particular amount to be paid to the respondent number 4. However, the question is whether prima facie any offense of cheating would be said to have been committed by the appellant. How many times the high courts are to be reminded to constitute an offense under cheating? There has to be something more than prima facie on record to indicate that the intention of the accused was to cheat complainant right from the inception. In this particular case, Your Lordship, admittedly in the FIR, it was paid initially.
That the stay granted in your matter by the High Court is only offense under IPC.
IPC,
There is no GPID.
not GPID, Your Lordship.
And the decision is
This is
pertaining to cheating,
but that-
whether offense of cheating is made out or not.
made out. And in the GPID, Your Lordship, because this is not a financial establishment, he is not a part of it. It is limited to the managing directors, managing persons of that establishment wherein the cheating was committed. So, in my respectful submission, Your Lordship,
There is no specification that it is confined only to directors and managing directors.
or any person engaged into the execution, Your Lordship, but it is my stand that he was not admitted into it. So on the law points as well as on facts points, you
As GPID is concerned, you can confine at this stage. I am not a financial establishment. It won't apply to me because it includes any other person also. So that definition is very vast.
and the transaction allegedly the 30 lakhs rupees was cash given. There is no record at the lordship as per section 173 subclause 3 of the PNSS. It says that when the offense is punishable between 3 to 7 years, a preliminary inquiry needs to be conducted before filing. There is no preliminary inquiry.
Not necessary in every case. Up to 7 years, then conduct preliminary inquiry. On the contrary, Sarla Kumari says other thing.
Lalita Kumari as well.
Lalit, not Sarla Kumari, but Lalita Kumari. It says something different. That is constitution based judgment.
With my respectful submission, your lordship, he would be available. And because 41 notice, then it is also mandatory. 35 PNS notice is mandatory as per the Supreme Court entry.
But there are also, then they will communicate the reasons.
But it has not been done ever.
You were communicated.
No,
You have been communicated the grounds of your arrest
the grounds of the arrest have been communicated.
because you were picked up by some agency.
I
Yes, you
was-
were not available.
I was picked up by, but
So
lordship.
in that circumstances, issuance of notice would not be necessary. A person is absconding, he is
But
on a flight risk, and if police arrest him, then how can you expect a
my
notice?
respectful submission is that once the FIR is filed, wherein the offense is punishable up to 7 years, it is a mandatory provision as per the Anish Kumar and Satyendra Kumar NTIV that the notice must be issued, but there is no.
Satendra Kumar Intel has specifically excluded economic offences, that category.
But there is, so far, the notice is concerned, it is not issued.
No, so far as economic offences are concerned, it would be having 7 years punishment.
Lordship, my respectful.
DPID have 6 years, maximum punishment.
They
is 6
have,
years.
just to make sure that the person suffers, they have invoked this GPA. Prima facie it is not made up.
Yes, that can be. Yes, ભાઈ હાલો તમે સમજાવો આ arrest ને ઈ બધું.
જી નહીં ક્રાઇમ બ્રાન્ચે પકડ્યા ને પછી આ ગુનામાં સુપરત કરે ને એ ડિટેન ટાઈમ છે સાહેબ.
ત્યારે તમને
ડિટેન કર્યા એમને સુપરત કર્યા 6-3 1 થી 2
બ્રાન્ચ કેટલા વાગે આમને કબજો
હા
આપો?
એમને એ જ મેં પૂછ્યું 1 થી 2 ના ગાળામાં કીધું.
1 થી 2 ની હવે 1
મેં એક્ઝેક્ટ ટાઈમ પૂછ્યો પણ એની પાસે નથી.
તમે આવ્યો છો?
હાજી
હા. ક્રાઇમ બ્રાન્ચે તમને ક્યારે આપ્યા એની કેસ ડાયરી લખી છે ને?
અટક કર્યા એમની વર્દી
સમય નહીં લખવાનો?
કેટલા વાગે તમને ક્રાઇમ બ્રાન્ચ આપે? મેં 4 વખત પૂછ્યું છે. હા ચાલતું છે જ્યારે તો કે 1 વાગે ને 2 વાગે ને 12 વાગે એટલે ખરા. કલાક અને મિનિટ સાથે કહેજો હો ભાઈ.
પછી 24 કલાકમાં રજૂ કર્યા છે?
હા બસ
અલા ભાઈ જી સર કેમ જોઈને કે ને
મને જોઈને કહો ને ભાઈ.
તમે અટક કર્યાથી 24 કલાકમાં નહીં. તમને પેલા મને એ
તમને સુપ્રત ક્યારે કરે?
ક્રાઇમ
Crime
બ્રાન્ચે
branch.
એને પકડો પછી તમને જાણ કરી. તમને ક્યારે કબજો આપ્યો? કઈ તારીખે ને કેટલા વાગે?
કેસદારી નહીં હોય કઈ. કેસદારી પહેલાની
કેસ ડાયરી લઈ લો.
અને પણ એમાં નહીં જોય.
15 સર અટક કરેલા
તમને પૂછીએ છે શું તમે જવાબ શું આપો યાર? લાવ મને જડ તો હું શોધું સાહેબ એને.
એએસઆઈ છો તમે?
હા
ભાઈ જ્યારે તમે સમજાવો તમારા પોલીસ
હા
વાળાને
સમજાયું સાહેબ કહ્યું.
કે જ્યારે કોઈએ જામીન અરજીમાં ગ્રાઉન્ડ લીધું હોય તો એની તૈયારી સાથે તો એફિડેવિટ કરે.
જામીન અરજીની કોપી મોકલાવું છું સાહેબ.
કોણ વાંચે છે? અર્નેશ
પછી-
કુમાર પછી ઓલો અંતિલ, પછી વિહાન કુમાર, પછી મિહિર શાહ, પછી BNSS તો ખાલી અમારા હાટું જ બનાવ્યું છે, પોલીસને તો લાગુ જ નથી પડતું.
ના
જો આજે બોલાવીને કેસ
હું કહી
ડાયરી
દઉં.
મંગાવો એની,
મંગાવી
અને તમે જોવો
ક્રાઇમ બ્રાન્ચ નું.
ક્રાઇમ બ્રાન્ચમાં, ના ના ક્રાઇમ બ્રાન્ચની મંગાવવાની ક્યાં જરૂર
ના ના
છે? તમે
આમની
ક્રાઇમ બ્રાન્ચ પાસેથી કબજો લીધો,
હા એ જે
ઈ
એ માહિતી
substitute.
લેલું છે.
એની કેસ ડાયરી જ મંગાવો એટલે એ જોઈ
એ
તો
ડાયરી તો
પડશે.
છે,
છે એમાં નથી જોઈને
એમાં તો સાહેબ નથી. ગુનો દાખલ થયા પછી શરૂ થયું છે.
તો કબજો લીધો ય નથી.
ના એવું
તો
નથી.
ગુનો દાખલ કર્યા પછી એને અટક કરવાના
હા એ અટક કર્યો એ જ બતાવેલું
ક્યારે કર્યો?
છે. એ અટકનો
ઈ તો એને
ટાઈમ
જ્યારે એનો ટાઈમ
આપી દઉં સાહેબ. એ છે 17-15. એ તો વાત
પછી
છે.
હા
અટક
હવે મને યાદ આવ્યું, આ તમે ઓલા 5 વાગે લઈને આવ્યા હતા,
હા એ જ
5:10.
અને આ સાદા ડ્રેસ ખાલી
That argument I am telling it right now,
જી જી
it is not impressive.
હા
કે 30 લાખ કેસ છે ને આઈપાક નથી આઈપાક કોને ખબર નહીં.
એક દલીલ એવી. બીજી દલીલ એવી હતી કે આ અમે ડિપોઝિટ પેટે નથી લીધા એમ, પણ એ ડિપોઝિટ જ છે. પછી ચોથી દલીલ ત્રીજી દલીલ એવી હતી કે
3% ને 6% વ્યાજ કીધું ને પછી
હા.
આપ્યું નહીં કાંઈ, એટલે
અમે ડાયરેક્ટર નથી ને અમે આ નથી ને અમે તે નથી.
એજન્ટ લઈ આવે છે.
બસ હું ટાઈમ આપી દઉં.
તમે આનું ખાલી જોઈ દો,
જી
અધરવાઇઝ. અને આના 3 જણા સિવાય બીજા કોઈ છે?
ના સર તારે અમને નથી. બીજા 2 ગુના છે. એક બોપલ એ ગઈકાલે રજૂ કર્યું.
અરે
પૂરું.
આમાં બીજા કોઈ સાક્ષીઓ છે?
ના તાર હાલ તો તપાસ હમણાં ફાસ છે નહીં.
તમે તો આ નથી કરતા તો ઓલું ક્યાંથી?
હા આ 3 જ પરણે શી
ચાલો,
કર્યું
આની કેસ ડાયરી ઓલું ટાઈમ નહીં આપો,
આપી દઉં છે.
એટલે કન્ટેન્શન લીધું છે ત્યારે.
હાજી. અને GPID માં સાહેબ સંખ્યા નક્કી નહીં હોત કે આટલા ભોગ બનનારો હોવા જ જોઈએ. એક હોય તો ચાલે.
એ બધું ટ્રાયલ વખતે જોવું આપણે.
હા તો
એની મેં ના તો કીધી કે ભાઈ
જી, જી.
GPID માં
જી.
જજમેન્ટ જે રજૂ કર્યું કે પેલામાં સ્ટે છે, એ તો IPC નો ઓફેન્સ એટલે સ્ટે કર્યો છે.
હા એ સિવિલ નેચર નો
કારણ કે
406 છે એટલે
એ સ્પેસિફિકલી ઇન કોન્ટેક્સ ઓફ ચીટિંગ છે.
Cheating.
ચીટિંગ છે કે નહીં?
શૈલેષ
એ
કુમાર
judgment તમારા
વાળી
અહીંયા
સિવિલ
અહીંયા
નેચર નું
you are
વાણી
putting
સાહેબ એમને
GPID
પોઝ
also.
કરી.
Let us આ ટાઈમ હશે તો then we will consider.
જી.
ટાઈમ નહીં હોય then on merits.
As per my instruction, Lordship, then the CCTV of the Jodhpur.
એવું બધું ના હોય.
એ બધું નહીં, રેકોર્ડ હશે આવશે.
In the morning it was handed over.
ક્રાઇમ બ્રાન્ચમાંથી ટાઈમ આવી જ જશે જે ટાઈમે આપ્યો છે. અને જે હોય ફાઇનલ, કારણ કે એમાં એ વખતે તો આવું બધું હતું નહીં કે
In the
આ તકરાર
in the
આવશે.
afternoon, one of my advocate had gone to the satellite police. He was there. So
We will not go by any.
Lordship,
You have
Lordship,
gone.
Lordship may very
we
much
got
go by
see,
the record.
But આના જેવું જો હોય clear cut, see,
It is.
in that case LOC was issued, so everything was perfect. Now here he was detained at airport, so the record would be absolute. There can't be any tampering, etc. You may also argue કે ના ના સાહેબ હવે એને ટેમ્પર કર્યું છે, ના છે ના છે, but that would be another thing. At this stage we will go by the paper. They can't change that paper.
ક્યારે hand over કર્યું અમને?
આપી
See, he may be taken by the crime branch. He may have gone there at 12 o'clock. There would be some procedural formalities also for handing over physical custody. But
મેડિકલ કરાવી.
two police persons, one of crime branch, one of other police station, meeting at crime branch, the presence of accused at the very same crime branch. That would not be the time. The time would be when actually the physical custody or possession of the accused was handed over to the
Satellite
this
police.
police station, XYZ police station. That would be the time. You can't say કે સર CCTV મૂકા આ તો હવારનો વયો ગયો થાય, but that would require કે કયા ટાઈમથી સ્ટાર્ટ થશે. But in that case 11 વાગે physical custody આપી હતી, that is a clear cut finding.
Lordship, in my respectful submissions, as per the guidelines issued by the DK Basu, when somebody is taking, even crime branch is taking physical custody, that is called arrest.
You file appropriate proceeding against crime branch also. So these are the things, okay, whether, what are the circumstances? The taking custody, coming at your home is a different thing. Taking custody while you are on flight risk, that would be another thing. A person who is absconding and police is searching for him, if that person is found out by a particular agency, then he can say, okay, 24 hours. Because suppose a person has committed murder here. Now he ran away into another state. After 6-10 months, he is caught from Assam. He can't say that this is
In my respectful submission.
so there are both aspects is required to be
Because
considered.
it is also in the law, it is very clear that even if there is a traveling time, they need to produce the person to the nearest magistrate. So the procedure as per section 58 BNSS and article 22 subclause 2 has to be followed in any case. Here's my response.
Whatever judgment you have produced, you go through that judgment once again. In one case, after Vihan Kumar, there is a judgment by the Supreme Court where the court has asked, okay, yes, these are the mandatory provision, but the circumstances are also to be looked into. Uncontrollable circumstances can be a ground to.
This judgment director of enforcement is latest your versus in respect of this custody. I agree with you, Roshan. But as per-
Don't agree with me.
it is my respectful submission that there is a violation.
You make your submission good. He will make his submission good. I will pass the order.
Very well.
Either of you will be aggrieved. They can challenge that order.
Very well.
Let us first get the time.
Yes.
Principle is very much clear. ચાલો એની કેસ ડાયરી ની બધું લઈ લેજો. તમે પિટિશન ક્યારે કરી હતી?
6/2014 સાહેબ ફરી ફાઇલ
પિટિશન હાઈકોર્ટમાં પિટિશન ક્યારે કરી હતી?
પિટિશન હાઈકોર્ટમાં સાહેબ જોઈ ન કહું સાહેબ એની કોપી મારી પાસે નથી સાહેબ ઓર્ડરની કોપી છે પિટિશનની કોપી મારી પાસે નથી સાહેબ સાહેબ 10/3/2017 રોજ ફાઇલ કરેલી છે અમારી સાહેબ એપ્લિકેશનમાં છે બિલિંગ
જોઈ લઈએ એક તારીખ